Good morning and good afternoon, everyone. Happy New Year of the Tiger. Welcome to the February 2022 APA Justice meeting. My name is Jeremy Wu. I'll be moderating today's meeting with a lot of help from Professor Stephen Pei and Vincent Wang. My role as facilitator is to keep the meeting on schedule, facilitate Q&A, and transition from speaker to speaker and from topic to topic. We're scheduled to end the meeting at around 1 p.m. Eastern Time. To stay on time, I may be rude and apologize in advance if I must interrupt because the allotted time is running out. We're recording today's meeting to help prepare a summary. Video portions of today's meeting may be posted publicly only with the speaker's permission. A written meeting summary will be posted at apajustice.org after the speakers have a chance to review it. Otherwise, the monthly meetings are off record. Please raise your questions or comments using the Q&A feature on your Zoom screen. We will try to address them as time permits. We have 4 new speakers today. Let me give a brief introduction at this time. First is Robert Fisher. Rob is a partner at Nixon Peabody LLP. He served as an assistant U.S. attorney for almost a decade. Rob is an accomplished trial lawyer and legal strategist. He recently defended MIT professor Chen successfully with the case dismissed on January 20th, 2022. Welcome, Rob.
Thank you very much.
Our second new speaker is Professor Chen. He's Carl Richard Soderberg Professor of Power Engineering at MIT and a renowned nanoscientist in the world. On the last full day of the Trump administration, then U.S. Attorney Andrew Leung held a press conference to announce the indictment of Professor Chen and openly questioned his loyalty to the U.S. His indictment sparked the We Are All Gang Chang movement across the nation and the globe. For more than 1 year, Gang and his family went through a living hell. Then the case was dismissed in the interest of justice about 3 weeks ago. We are privileged to have Gang to share his story and views with us today. Welcome, Gang.
Thank you.
Our third new speaker today is Zhigang, Alan and Marilyn Puckett Professor of Mechanics and Materials, Harvard University. Zhigang is a renowned scientist and a prolific tweeter. One day he would talk about the high throughput experiments for rare event rupture. And then another day, he would comment on humanity and daily life with wit and depth, all in 280 characters or less. The day after Gang was arrested on January 15, 2021, Zhigang issued one of his most memorable tweets. Zhigang, we welcome you and look forward to your insightful remarks as a colleague and a friend to Gang and all of us. Our fourth speaker is Carol Lam, former U.S. Attorney for the Southern District of California. She and I, serve as commentators for a Committee of 100 report on the Economic Espionage Act prosecutions last September. And Carol gave some profound observations, and I'll read some of it here. Quote, every criminal prosecution features unique facts and a unique defendant, and it is a prosecutor's obligation to consider each case on its own merits. But initiatives create, perhaps inadvertently, perverse incentives. When a criminal prosecution is brought as part of an initiative and therefore tagged as a statistic, for a future press release. It allows errant motives, poor judgment, and/or incompetence to creep in. That's because a criminal prosecution initiative imposes an arbitrary goal, often with an arbitrary deadline, and as law enforcement scrambles to reach that goal, it disrupts the natural rhythm of criminal investigations, end quote. Carol will be sharing her views on Gang's case and more generally, the China Initiative. Welcome, Carol. Now, in addition to the four distinguished news speakers, Nisha and Gisela will be giving us updates from KPAC and Advancing Justice AAJC, respectively. Now, February 1 was New Year's Day for the Year of the Tiger, according to the new lunar calendar. We're deeply honored by having Erika Moritsugu to help us kick off the new year. Erika was appointed to serve as Deputy Assistant to the President and Asian American Pacific Islander Senior Liaison last April. Before she could sit down in the White House, she spoke to us in the May monthly meeting. She was already on the road at that time, telling us about the fear of a well-known unnamed Asian American movie star for his biracial kids, as well as the vision and responsibilities of her new role. Now, as the eyes and ears of the AAPI community for the president, Erika was also asked how the community can help her to strengthen and sustain her role. So it is 9 months later. Erika, we welcome you back, and please give us your views and an update from the White House.
Thank you, Dr. Wu. Thank you so much, y'all. It's wonderful to be back here with you in this Zoom, although I've had occasion to speak with many of you individually over the course of, Jeremy, I hadn't realized it was 9 months. It's a full gestation period almost. And a wonderful Lunar New Year. So hoping that in the spirit of the Year of the Water Tiger, that you're embracing 2022 with strength, bravery, and vitality. But also, before we completely leave the Year of the Ox behind, I wanted to take a minute to reflect on the last 9 months, last year, and all that we've accomplished. It does go without saying that 2021 was a difficult year. The dual crises of the COVID-19 pandemic and the spike in anti-Asian hate have taken their toll on our communities. But at the same time, there are a number of victories worth celebrating. As you've seen, in his first year, the president was swift to speak out against and combat anti-Asian hate, including in his first week in office, issuing a presidential memorandum condemning racism, xenophobia, and intolerance against Asian American and Pacific Islander communities. In May, just a little bit after I spoke with y'all, he signed the COVID-19 Hate Crimes Act and the Jabara Hire No Hate Act into law. And we've been doing other things like overseeing other measures like providing $21 million in funding for state and local justice programs to investigate and prosecute hate crimes, and translating Department of Justice resources and information about hate crimes reporting. The President also made advancing equity, justice, and opportunity for Asian Americans and Native Hawaiians and Pacific Islanders a top priority by signing an executive order reinstating the White House Initiative on Asian Americans and Native Hawaiians and Pacific Islanders. It was just last week that the Vice President swore in the new President's Advisory Commission on AAN and HPIs, which is co-chaired by Secretary Javier Becerra of Health and Human Services and Ambassador Catherine Tai, our U.S. Trade Representative. We had 2 full days of meetings featuring speakers like Ambassador Susan Rice and Assistant Attorney General Kristen Clark, commissioned officers from the Gender Policy Council and the National Economic Council and the Office of Science and Technology, and senior officials from HHS and outside experts to help us launch our work and scene set and understand the scope of this ambitious executive order that we're going to be doing a lot of work on in the coming months. And under the President and Vice President's leadership, the administration has already increased diversity and representation across the federal government of AAN and HPIs to create one of the most diverse administrations in history. Within the White House, 17% of White House staff self-identify as Asian American, Native Hawaiian, and Pacific Islander. And across the agencies, 15% are AA and NHPI, including leaders of key agencies. We've also reduced barriers and increased Asian American and Native Hawaiian and Pacific Islander access to federal services like affordable housing. We've provided immediate relief to AA and NHPI families through the American Rescue Plan, reducing poverty in AA and NHPI communities by nearly 22%, and reducing AA and NHPI child poverty by nearly 30%. We provided $106.3 million worth of loans to Asian American and Native Hawaiian and Pacific Islander-owned small businesses and supported students by providing more than $36 billion to higher education institutions that primarily serve AA and NHPIs. Last month, and Jeremy and Stephen, maybe we can send a link around. We released a fact sheet that extensively details all of the steps that the Biden-Harris administration has taken in our first year in office to advance equity and opportunity for AA and NHPIs. And I'd encourage you to take a look at it. It's a good document because there was a lot of good work. But while we're incredibly proud of what we've accomplished for our communities so far, we recognize that we still have a long distance to go in ensuring safety and equity for AA and NHPIs. That's why in 2022, we're going to continue striving to make progress for our communities, including by lowering costs for American families and fixing supply chains and by advancing the President's Build Back Better plan. I know I'm running short on time. I should have spoken quicker, but I did want to address some issues that I know that are top of mind to y'all here today. First, with respect to research security. The Biden-Harris administration is committed to ensuring that the U.S. government assiduously avoids basing policies or processes on prejudice, including those that could fuel anti-Asian sentiments or xenophobia in relation to research security. We're committed to affirming the integral role of AA and NHPIs and people of all national origins in this country and supporting collaboration with international partners when it is in our interest. Since January 2021, the Office of Science and Technology Policy has been working on how to implement the National Security Presidential Memorandum, NSPM 33 across the federal government. The federal government is collaborating with researchers and research institutions to develop implementation guidance that, number one, protects America's security and openness. Number two, is clear to researchers. And number three, does not fuel xenophobia or prejudice. I think many of you are aware that OSTP has had briefings with members of Congress, a special meeting with civil rights leaders, and an additional meeting with academic and research community members that are directly impacted. So we're going to continue to engage with America's remarkable and diverse community of researchers and institutions to ensure that the guidance upholds those core values. In terms of the China initiative, you know that I'm not able to speak about individual cases because that's a matter of purview for the Department of Justice. But I do want to be clear that racial profiling has no place in our society, not by private companies, institution, or law enforcement. I want you to please note that the Department of Justice at the highest levels fully embraces its mission to combat discrimination and is deeply committed to enhancing trust, rebuilding trust with the AA and NHPI communities. The Department of Justice has been very engaged in initiatives to respond to and combat anti-Asian hate, including by holding listening sessions with AA and NHPI community groups and meeting with U.S. attorneys across the country to request feedback on hate crimes, community outreach efforts, and data collection. And they're deeply committed to protecting Americans, whether their race or national origin, from exploitative and coercive conduct by the PRC government, including targeting dissidents and others who criticize the PRC for their human rights abuses. Finally, I was encouraged to see the confirmation of Matt Olson to be the Assistant Attorney General of the National Security Division, which has purview over the China initiative. Mr. Olson has extensive national security experience and an extensive background in civil rights. And in his confirmation process, he committed that in describing espionage threats posed by China, he would, quote, strive to make clear such threats originate from the Chinese government, not the Chinese citizens in general, and certainly not American citizens of Chinese origin or descent. And since being sworn in, I've personally observed the intentionality with which Mr. Olson has been reviewing this program, including meetings with community leaders in the affected community, as well as the Congress. So here we are, a full year into this administration, and with the confidence of a president and a vice president who I believe truly see us and hear us and value us, and who are committed to providing us with the safety and opportunity we should expect and can now hope for, we're going to continue to execute on our vision to empower Asian Americans, Native Hawaiian, and Pacific Islanders. We look forward to continuing to work hand in hand with all of y'all, We're excited to see what greater progress we will bring in this year of the Water Tiger together. So mahalo for the opportunity to share this space with you. I am going to turn it back over to you, Dr. Wu.
Thank you, Erika. Quick question, if you know, when would the review of the China initiative be completed?
I don't have a timeline certain. It was reported in the press a couple of weeks ago that it was due within a month or a couple of weeks beyond that. So I'm hoping soon. Okay,
great. Thank you.
Thank you.
I know you have a busy schedule, but please stay as long as you can, as your schedule permits.
Thank you. Thanks, y'all.
Nisha, KPAC has been very busy. Would you give us an update for about 5 minutes?
Sure. Thank you, Jeremy. Great to be with all of you again. KPAC has, in fact, been very busy. So happy to update you. I know in the agenda that I think you had sent around, there was a link to just following on Erika's statements, following onto that. Assistant Attorney General Matt Olson met with KPAC members last month. Last month, and wanted to make sure that you'd all seen that statement. So I'll drop it in the chat afterwards, but I know you'd also link to it. We also do not have any further information on that front. What I really wanted to update a lot of you all today on was the work that we've been doing around the America Competes Act. I know we've had conversations in this forum before about concerns related to the Senate version of Senate version USICA, and some specific provisions targeting Asian American researchers and other Chinese and Chinese American individuals particularly. And so similar to, I think, what we've heard in these calls before, once the House version, America Competes, came out last, I guess technically the week before last, we reviewed, KPAC did a thorough review and certainly found that the House version of that bill was much more acceptable for protecting civil rights and civil liberties of Asian Americans in particular spaces, in particular sections that USICA did not. And I know we had Union of Concerned Scientists, we had Joanna on speaking about this in particular, but wanted to flag it again just as something that we've been tracking very closely. I specifically wanted to point out, as America Competes passed in the House last week, that Congresswoman Chu, along with a number of KPAC leadership members and Congressman Raskin and a couple of others, had an amendment that passed in there, specifically reaffirming opposition to targeting Chinese and Chinese American researchers and scientists based on race alone. Additionally, there were a few other amendments, both by Congresswoman Eshu and by Congresswoman Meng, around ensuring that anything passed through this bill does not further harm Asian American individuals across the country based on discrimination or hate. So those were part of the amendments that passed and that is now passed by the House. Largely, KPAC's concern through this bill has really been around the rhetoric, around heightened anti-China rhetoric that we were expecting to hear, and we did hear on the House floor in debate and from a number of individuals who've been really pushing to make this the focus of this bill on China rather than on American competitiveness and innovation. And so want to shout out, especially Erika, I hear the Biden administration on their statement of administrative policy, and Speaker Pelosi, we also saw, had a great statement that, didn't even mention China as a focus of this bill, but rather focusing on what this legislation would do to help American competitiveness and innovation, and help members, constituents across the country. It's something that we've been very, very focused on, that Chairwoman Chu has been very, very focused on, in continuing to push that messaging out towards the rest of our colleagues as well, on how to speak about China without fanning the flames of hate against Asian American communities, and also on focusing on what the bill does for us rather than solely on fear of another country, regardless of where that may be. We've had a lot of response to those from colleagues and from other offices on the Hill. And I think, the work that you all do as part of pushing for those same, protections for Asian American researchers and scientists is really helpful. What I can say now is that our next step in this process is working to express our concerns on the Senate bill to House and Senate leadership and push for, what KPAC sees as a bill that does not cause harm for Asian American communities. And so we'll be continuing to work on that closely. I'm happy to keep chatting with you all about that as needed. I do see a question in there. I will certainly drop in the link to the amendment in just a moment or two. But happy to take any other questions. I think those are kind of that's the big update at this moment. But happy to talk more about any of it in particular.
Thank you, Nisha. We do have some questions, but let's defer perhaps later on for the meeting. And at this time, Rob and Gang, you allotted a total of about 20 minutes. Rob, would you please set the stage with your observations about Professor Chen's case, and also pass the floor to Gang when lessons on what lessons he and the rest of us should learn from yet another, what I would call debacle, called the China Initiative. Rob, the floor is yours.
Sure, happy to. Thank you, Jeremy. Thank you, everybody, for having me and Gang on today. I just want to take a few minutes and give an overview of sort of how myself and the legal team handled Gang's matter. And then I want everybody to hear from Gang, and I'm happy to answer questions, after Gang speaks or others. But I met Gang in January of 2020. So even though people read in the press that this was a year-long road for Gang that was very painful, it was actually 2 years. Gang was stopped by federal officials at Logan Airport back in January of 2020. And his electronic devices were seized, and he was questioned for a matter of hours. Gang, even though I didn't know him at the time, he hadn't retained me yet. He did not say a lot to the feds, which was good for him, because I have to tell you, I have many other clients now involved in the China Initiative. One that's been charged, I think 5 that have not been charged. And what I see as a common theme are people not understand. I see this in other matters I have too, including the case with the Stanford sailing coach I had as part of the Varsity Blues prosecution here in Boston. When agents come to speak to individuals, they don't sometimes know enough to say, I'm happy to speak with you, but let me get my lawyer first. I want to speak to a lawyer, and then I will sit with you for as long as you'd like. And I see it time and time again that agents will go to folks' homes or get them at the airport, and individuals want to cooperate because they feel they've done nothing wrong. And in Gang's case, he in fact did do nothing wrong. But we all know that sometimes things are misunderstood. Agents don't take clear notes, they don't produce clear reports, and they misunderstand things, and that gets used against you. And then it's an uphill battle from there on in. In fact, I have a new client who just retained me late last week. Again, it's a China Initiative prosecution, and he spoke to federal agents, FBI agents, that went to his home for 4.5 hours. All right, nothing good is going to come of that. So Gang did himself a great service for not having a lot to say at the airport. They kept his devices. He spoke to MIT. MIT sent him my name, and he retained me. Of course, then it was a year-long process trying to get information from the government in terms of, what are you looking for? Is Gang a target? In us offering to come in and speak to the federal government. Because what traditionally is done is they say, yeah, your client is a target. Would you like to come in and give an attorney proffer and let us know if your client has any issues? And then the government will give us a reverse proffer and tell us what they're seeing in terms of their investigation with that target. That never happened. I think it would have happened, but for the administration and the waning days of the Trump administration wanting to bring this case. because in my communications with the lead prosecutor, shortly before Gang was indicted, I was told there was probably another 5 to 6 months of investigation left to do. And then I would be told and come in and give a presentation along with my colleagues from MIT. They were being ably represented by folks at WilmerHale who were trying to give presentations, because obviously WilmerHale did an internal investigation. They didn't see any troublesome activity with Gang. I did my own investigation by meeting with Gang many, many times, along with my team, going through his emails, going through his grant documents, and we didn't see any issues. So typically what happens is I have the opportunity to go in and meet with the government and say, this is the work I've done. I'm not seeing problems. Instead, there was a very rushed complaint. It wasn't even an indictment yet, which folks who practice in the federal system, such as Carol Lamb, understand when you have a case done by complaint, that's usually because there's a time is of the essence and they want to get somebody in custody, not for a case like Gang, who had been under investigation for, at that point, over a year. So Gang was charged by complaint, arrested, and then indicted 5 days later, which indicated to me they had clearly rushed this prosecution, this indictment. And I think why they did it is so the U.S. attorney could get a press release, since he was one of the individuals on the DOJ task force for the China initiative. And then that began the year-long litigation process, which we were victorious in because we went in the offensive right away. We filed a sanctions motion against the U.S. attorney because of public statements he made, which were completely inaccurate and incendiary. We then went on the offensive trying to get Brady documentation and information from DOE regarding why they had changed their grant forms in 2020, because as became clear to us, the grant forms that Gang was charged with were from 2017 and 2019, before the language had changed to encompass overseas or international collaboration. And of course, that then led to Brady disclosures late in the year of 2021. And then, of course, I think the final nail on the coffin was the interview DOJ had with DOE to confirm that DOE, in fact, would not have even considered this collaboration material for the 17 and 19 forms. And that was obviously critical and very material to our case. And that led to the dismissal. But that was a very difficult 2-year process for Gang and his family. Frankly, it's something that never should have happened. And I don't think it would have happened if this case hadn't been rushed. In fact, some of the evidence that the U.S. Attorney's Office uncovered that led to the dismissal should have been gathered by them in the grand jury process prior to the indictment. But as we saw, they didn't even charge Gang via indictment in the beginning. It was done by a complaint, which indicated to me clearly it was a rushed process. And they were doing this in part because it was going to be a last press conference for that U.S. attorney and the director of the FBI here in Boston. So I'm sorry, that was a lot. I tried to cover a lot there, but it was a very long process. It was 2 years. But I think it's important for folks to hear from Gang because he lived it from an academic's perspective, which I think he'll tell you really surprised him that they were even doing these cases. Not a lot surprises me anymore because I've been living in the federal system now for well over a decade. So I see this back and forth in these type of cases, unfortunately, on a regular basis. But from this point, I'd like to give Gang the floor. And of course, I'm happy to answer any questions about the details of either our strategy or how DOJ went about prosecuting this case.
Thank you, Rob. Really, your team did a great job. I also want to thank all the people here, the community support, MIT support. Really, it's crucial for me to win this battle. And Rob already mentioned some details, so let me just briefly recount that in January 2020, when I went through the airport with my family, I was detained there for 3 hours, and they interrogated me and took all my electronics away. So after I came back, I reported to MIT, and MIT arranged me to have a lawyer and pay my legal fee. And MIT continued to pay my legal fee until even now. I'm very grateful. And MIT also hired an external lawyer, as Rob mentioned, and they did a 1 year looking into details and didn't find anything wrong. And yet they arrest me on January 14, 2021, just to say within months before that, as Rob mentioned, they told him there was no imminent indictment. Clearly, they rushed the case. And it's a very hard year. I just want to share because the entire prosecution is full of misconduct. And from the indictment to search affidavits to a criminal complaint, I will summarize to you the 7 patterns I see where the misconduct happened. And the first one of this misconduct is they really alter the facts. And this is evident in their criminal complaint. For example, in February 2016, MIT hosts a Chinese official. And during the meeting, I used the phone to take notes. I sent to me as an email. In prosecutor's criminal complaint, they copied every word of their email except the last sentence. And they said this email is my promotion of PRC's strategic goal. And they cut off the last sentence because the last sentence read, Mr. X, let us work together. Here, Mr. X, this is the name of an MIT official who hosted the meeting. Had they included this last sentence, it would become very clear that this is a note, not my thoughts. And what's scary is in the court, when we ask a sanction under learning, the prosecutor, Stefan Sigman, said, this could be his notes, but it also could be his state of mind. And then later learned this was her way of building up my criminal intent. And this is so scary. Number 2 is they interpret normal scientific activity as crime. For example, on the day of my arrest, the prosecutor told Rob that among all the evidence they listed, she was most angry that I serve as expert reviewer for the Chinese National Science Foundation. I think many people in academia routinely review proposals for other countries. In fact, I know that US Department of Energy used reviewers from abroad because I was in the same room with these reviewers. Review proposals, paper, writing recommendation letters are the things we do as our job for free. Yet the prosecutors interpret that doing review is a service to the Chinese government. That's why so many professors, scientists are so angry, scared when they say the charges they put on me, because what they charge me apply to them too. And number 3, they use the email I did not reply as evidence of my crime. In fact, despite that I review many proposals for many countries, it just happened I never review a proposal for the Chinese National Science Foundation, not in my memory, not in any email trace. None of us had any control if people collect our information and put it in a database, right? All information is all public. But because my name was in their database, I guess, the prosecutor said I was a reviewer expert and I was serving the PRC government. Number 4, even if I did the right thing, they said I hide something. For example, because I was an academician of Academia Sinica in Taiwan, I got an email from an officer in Taiwan's Boston office and explained that he wanted to pay me a visit. I vaguely remember that there is a restriction in terms of foreign officials visiting campus, and explained to him that I could not do that. Although he said Taiwan is not on the list, well, out of courtesy, I met him, but outside MIT, we had the lunch outside. And yet that meeting was cited as evidence that I was hiding something in one of their search affidavits. Of course, number 5 is they rushed the case, they didn't do their job, as Rob already explained. They had 1 year, and yet they did not do investigation, they did not interview critical witness. And they rushed the case because the US Attorney Andrew Lenin was to leave office. Number 6, they hide the truth. On the day of my arrest, right? They interviewed a few people, and one of them, so everybody told them truth, but one specific witness clarified to them that I was not in the Wuhan, Thailand program they accused me. And in March 2021, the prosecutors interviewed MIT grant administrator specializing on DOE grant. She explained there was no requirement to report what they accused me at the time for DOE proposal and the annual report 2007-2019. So we know by US law, the prosecutors must provide such exculpatory information to Rob, my lawyers, but they never provide to them until Rob went to demand them in November. We knew they had. And they actually turned a lot more, those kind of exculpatory information. And they knew they could not hide anymore. That's why they start to drop the say case. And number 7, but they never admit mistakes. No one opening official apologies to me, despite that they knew that they are wrong. Because they knew they had no evidence, they rushed the case. They actually wanted to get out. And yet they still try everything to save face. They first offer the deferred prosecution agreement. Rob would tell that is very rare, but yet we know this offer was about saving their own face, not about my innocence. I turned it down. And that's in their dismissal, they cited new evidence because on January 4th, 2022, Stephanie Sigman called the US Department of Energy, and they said I didn't do anything wrong. Their indictment mentioned the DOE 16 times. They could have called them before that. They have clarified before that. They could also have called them at the time March when they interviewed MIT grants person. They never did it. And yet their dismissal just use the excuse, we have new evidence. I actually wish that the judge had a hearing, but that didn't happen. Really say, that's why I respectfully ask the Congress to investigate all those misconducts. They say DOJ, of course, should do their own investigation and learn the lessons, but congressional investigation will be more objective. I also want to share just a few major lessons I take away from this. I think we could all learn from it. 1, we are all losers. US is the biggest loser because we lost Thailand. 2, universities need to protect their faculty. 3, funding agency need to do the right thing. 4, for vulnerable people like us, we need to learn our rights. 5, we need to speak up. Let me just say, we are all losers. US is the biggest loser. Because Andrew Lenin had openly said they want to create a chilling effect. With wrongful prosecutions, they did achieve their effect. They terrorize our people. The terror drives talents away and deters new ones from coming. A colleague told me, this after my case was dismissed a few hours after, that this is the MIT faculty, he's leaving the country. And he said 3 of his academic friends already left because my case really broke the last straw, as they said. The brain drain historically precede decline of relation. The loss to US is incalculable. We should know that. Many of my colleagues say that my cousin is coming back. Number 2, university leadership. In fact, beyond that, professional society, industrial leadership should stand out, protect our people. MIT set a great example. The MIT president and leadership defend me and financially and morally. And MIT faculty stood up quickly, even though they didn't know the facts. They just read the complaint and they realized this is too dangerous, so dangerous. I particularly want to praise the Professor Yul Fink because he really led MIT faculty to stand up. And this is a good lesson for all the other universities to follow, the faculty and leadership. 3, funding agencies also need to educate their manager and defend their researchers. In my case, Dr. Chris Ford, the director of DOE Office Science, said a few weeks ago that I didn't do anything wrong. But DOE could have stood up when they read it because all my indictment was based on DOE. They mentioned DOE 16 times in my indictment. And number 4, for people like me, we need to know our rights. Just like Rob mentioned, we should not speak to them without a legal representation. This is a really hard lesson for many of us, right? Not just ourselves, we need to teach our family, tell our family the rights. Number 5, I'm a scientist, and I never thought that I would be involved in politics, activism. It's a hard lesson. Politics impact everyone. We must speak out. As Martin Luther King said, injustice anywhere is a threat to justice everywhere. So I think with this, I will stop here because of time. I really also want to mention that the personal toll is to my family, to myself, to my research career. It's just to say, really, I cannot describe easily. It's very hard for us. Thank you.
Thank you, Gang. I think that the talks have been so compelling that we must extend the meeting rather than cut it short. So I beg for your understanding, and we will run over the 1 p.m. timeline, but I think you will find this extremely valuable, that we should continue. So at this time, is Dr. Stefan Maier on, Stephen? Let me see, I think Stefan is here. Okay, Stefan, you're on. Stefan is from Germany, and he has a question for Professor Chen. Good evening, Stefan. Would you raise your questions briefly?
Yes,
the floor is yours.
everyone. Thank you very much for being here and doing this great work. I'm very happy to see Gang again as a free man, basically. And yeah, my question would be, so Gang, you kind of dedicated your whole life to research and science, and I guess these recent events were quite traumatizing, and it's mostly from a perspective of the global scientific community of what we can do to actually support and help prevent these kind of events, and what we could do to preserve these values of free scientific collaboration in times of competition for next generation technologies.
Stefan, it's so good to see you again. And we actually just met last Friday, and I'm so grateful for people like Stefan in international scientific community support, not only just from US. You raise a very good question. I just say give a crack over your question from 5 points here. First, we know very well that ideas are often generated through interactions and collaboration. And without an open environment for scientific exchange, the progress in science will slow down. But humanity's existential threats has no boundary, right? We have seen from pandemic and from global warming, this problem cannot be solved by one country. And I also want to say scientific discovery is not a zero-sum game. The more scientific advances we can make, the more progress we can make, the better solution come up. Everybody will benefit. And of course, there are competitions. I think, the competition between countries can learn from industry. We know semiconductor industry, for example, have Sematech, where all the competing companies work together to address the issues of their common interest. Company can do that. Country can also do that. And the final point is the basic research we do from university, right? Create a common knowledge. And in fact, based on this knowledge, industry can make money that become proprietary. And I think in 1985, at the height of Cold War, President Reagan issued the NSDD 189, which is the National Security Decision Directive, in which it reaffirmed that fundamental research, which include basic and applied research, should remain open to the maximum extent possible. Many of us in academia think that's a good guideline, and we still see the one that we should follow. So I really think this international collaboration is everybody. So we all benefit. The humanity benefit. Thank you.
Thank you, Gang and Stefan. At this point, let me turn the floor to Zhigang.
Hello, thank you. The ordeal of Gang Chen teaches many lessons. Here I focus on one lesson: countervailing power. On the day when Gang was arrested, the government displayed overwhelming power. They jailed, handcuffed, and shackled Gang. They press released misinformation, defrauded 19 million in federal grants, received 29 million in foreign funding, right, to promote China's development. Now we know, false, false, false. They're all documented lies. The government packaged the information and fed it to the public in fear. The China threat, the misinformation traveled fast on the same day in papers and on screens all over the world. On the day of arrest, the MIT president issued a statement. For all of us, quote, for all of us who know Gang, this news is surprising, deeply distressing, and hard to understand. The statement was widely quoted in the news. Also quoted was Gang's attorney, Rob Fisher, here. Gang's life has been epitome of the American dream. He loves the United States and looks forward to vigorously defending these allegations, unquote. But on that same day, the significance of these statements were lost on me. I could only see talking heads on screens emit virulent stench. Bewilderment, anger, sadness, fear. On that day, my friend, Professor John Doble, tweeted, so sorry, quote, so sorry to hear the news about Gang Chen at MIT. I hope that it is a big misunderstanding and that he is acquitted of all charges. On the following day, I retweeted John and wrote, Gang has been my best friend. Gang has a beautiful mind as a scholar and a kind heart as a human being. He is devoted to his family, friends, colleagues, and MIT. He was born in China and found his dream in America. The news made me want to cry. In the evening, Ellen Barry of the New York Times called me. I saw your tweet, she said. Why do newspapers amplify government's misinformation? I asked. I was rude. Well, newspapers report news, she said. An arrest of a professor is news. which the government provides. We report the news with whatever we have on that day. Subsequently, we investigate more and report further. I'm talking to you now. Thank you, Alan, for this illumination on a day of darkness. On that weekend, I saw the criminal complaint on Twitter. Several aspects of the complaint jumped out to me. It was written in plain English. It made absurd allegations. The author was named McCarthy. I hit on an idea. Why not study this McCarthy document as if I were reviewing a technical paper? I reviewed the complaint point by point in a long Twitter thread. In an opening tweet, I wrote, "The McCarthy document is a basis for the arrest of Professor Chen. This arrest is an act of a government against an individual. The power asymmetry between a government and an individual is enormous. We, the people, should do everything to ensure no abuse of power." The public attention to Gang's case has been stunning, swift, and sustained. On the day of Gang's arrest, Professor Yo Fink started to organize the MIT faculty support, which soon led to the "We Are All Gang Chen" letter. Many individuals spoke out early, thoughtfully, and forcefully. Civil rights groups, including APA Justice, instigated a congressional roundtable. Professor Kai Li, Yasheng Huang, and others launched Asian American Scholars Forum. Newspaper reporters interviewed many people and published substantive findings. Once the government makes allegations transparent, here's a lesson. They can be scrutinized by the public if we were interested. In hindsight, the tide of a public discourse turned soon after the arrest. The government has never recovered. The experience teaches a fundamental lesson in civics. Power corrupts. Absolute power corrupts absolutely. Yet, by design, our own government does not have absolute power. We, the people, are cultivating power. Thank you very much.
Thank you, Gang, and Zhigang, and as always, for your very insightful remarks. Carol, may I at this point turn the floor to you?
Yes, thank you very much. And I want to thank you all for giving me the opportunity to speak today. Let me try to offer my perspective on the criminal justice system and how, without a lot of deserved introspection, it can lead to some terrible decisions like the ones that resulted in the terrible experience that Professor Chen went through with his arrest and the failed prosecution. Criminal prosecutions, they stand apart from other types of efforts and mechanisms that exist to try to achieve fairness and balance in our community. It's the only mechanism where life and liberty are at stake, where it can be taken away from you. And because of that, there are other protections, extra protections that exist for those who are charged with crimes. There's the right to counsel, the right not to incriminate yourself, the right to a unanimous jury of one's peers, the right to be found guilty beyond a reasonable doubt. But virtually all of those protections come to the fore. They take place only after the charges are actually brought. And before that point, there are decisions, for example, whether to open an investigation, whether there's sufficient evidence to bring a case, whether to effect an arrest, And at those stages, there are very few protections that exist, except for what we hope is the good judgment of the people doing the investigations. And my concern is that we have a Department of Justice that has fallen in love with the idea of criminal prosecution initiatives. That is a declaration of a concentrated effort to focus criminal prosecutions on a particular type of crime. And unfortunately, when DOJ dangles that kind of incentive and reward structure in front of its agents and prosecutors, a lot of that good judgment goes right out the window. So let me give you a couple of examples, and thank you, Dr. Wu, for quoting from my commentary. You probably made my presentation a little shorter, but I do discuss in there a couple of criminal initiatives that I experienced during my almost 20 years at the Department of Justice. For example, in the savings and loan scandals of the 1980s, the Department of Justice decided it would be great idea, get money from Congress, create these financial institution fraud initiatives, these groups of specialized prosecutors and agents who would go out and take down these big financial institution fraud cases. Well, of course, the first problem is there weren't big hordes of experienced prosecutors and agents who knew a lot about big financial institution fraud, so you had to sort of drum up people who didn't really know a lot about how to do those cases, but you had to create these units because now you had the money to do them. And the other problem is those cases are really hard to bring. They're hard to prove, and fraud cases are not like they're different in nature from violent crimes or drug cases where a crime is actually being committed. You just have to figure out who did it and what the motive or intent was. But in these fraud cases, sometimes you don't even know if a crime has actually been committed. And this is the problem that we saw here with Dr. Chen's case and a number of other cases. So eventually, a kind of panic ensues in these task forces because they're not producing as many cases as they were expected to produce. And so they start looking around for cases that they can either bring or cases that already existed that aren't really that important, but they can kind of sweep into the category of a financial institution fraud case. And what I came to see is that we were bringing a lot of bank teller fraud cases, tellers who might secretly write a check for $2,000 to themselves and cash it in their position as teller. Yes, it's a crime, but it's not the kind of crime that caused the initial initiative to be created. Another example, about 15 years ago, the Department of Justice, with the big immigration debates that were going on, decided that they would bring cases, another zero tolerance initiative against anybody who at the Mexican border presented false documents at the border. And, facially that seems to make sense because if somebody's actually going to present false documents, it sounds like a more sophisticated crime. But actually what ended up happening was they were bringing hundreds of cases against nannies who worked in the United States, went home to be with their families over the weekend, and were presenting false driver's licenses at the border to come in. Yes, a crime, but certainly not the crime of the level that justified the pouring of resources into this particular initiative. And what would happen is the nannies would be arrested, they'd be brought into court, they would plead guilty to a misdemeanor, get time served, and released. Absolutely no criminal impact at all, criminal prosecution impact on the district. The point is that the tragedy that happened to Professor Chen and is happening to others in the United States is that this criminal prosecution initiative is warping the good judgment that has to be guarding the door against wrong-headed investigations and prosecutions. I'm sure that Professor Chen, you're never more proud than when a student of yours does a great job with fantastic research, and I'm sure you're never more disappointed than when you find out a student has not done a good job and has not done the level of research that they should be doing. And I feel the same way about poorly done investigations and prosecutions at the Department of Justice. Criminal prosecutions are very individual efforts. You can't create evidence through chest thumping or waving around the banner of a criminal prosecution initiative. It is completely predictable, in fact, that criminal cases that are pursued in the name of an initiative are going to become smaller, they're going to have thinner evidence, and they're going to get further away from what was supposed to be the purpose of the initiative. DOJ should be mature enough to recognize and acknowledge today that initiatives do not give rise to good cases. In fact, quite the opposite. They give rise to poorly investigated, poorly conceived cases that are pursued for all the wrong reasons. If you have a good case, investigate that case well, bring a good case, get a conviction. You can boast about it all you want at the end of the day, but what DOJ is doing today is misguided. They know that now. They should be taking steps to repair that. You can argue they're taking some steps now, but it is very, very late in the day. Let me just close by saying that, I don't like to come out and criticize the Department of Justice. I don't do what Mr. Fisher does. I'm not a defense attorney, even though I have suffered at the hands of DOJ a little bit myself in the past. I am basically a believer in the institution. I think it's an important institution. I think by and large, the people who have run the Department of Justice and worked in the Department of Justice are good public servants. But there are times when I can see indications, even from afar, that the train is running off the tracks. I am very concerned about the statements that have been made by DOJ officials, mostly in the past, but not that far in the past. Statements by the Boston U.S. Attorney that basically he said, we've done our job, the research community is terrified now. We're not supposed to live in a world where we bring criminal prosecutions to terrify a larger population and then our job is done and we go home. DOJ is supposed to speak through its cases, not through innuendo and suspicion. I heard a statement by the same U.S. attorney that there's nothing wrong with calling this a China initiative, because if it were the French government that was trying to steal our technology, this would be called the France initiative. That's just insulting. We're not writing on a clean slate here. This is a DOJ and a government that enforced the China Exclusion Act and interned, thousands of Japanese citizens, U.S. citizens of Japanese descent, I should say. We're not writing on a clean slate. This is not a France initiative. And perhaps most disturbing, they're all disturbing, but perhaps most disturbing to me was a statement by the former, not the current, National Security Director that seemed to try to be justifying the dismissal of the 4 visa fraud cases, one of whom was at Stanford, which is an institution I'm affiliated with, that 1,000 researchers have now returned to China in the wake of these prosecutions, as if we were in the Old West and we simply said, get out of Dodge by sundown. This is not the way the Department of Justice is supposed to operate. And does anyone really question that, as Professor Chen was noting, a lot of them are leaving because they're terrified that the government is treating people of Chinese descent unfairly. So these are all indications to me that there's something astray at the Department of Justice, and I'm happy that these efforts are going on to try to unwind them. I am disappointed it is taking the Department of Justice as long as it has to be unwinding this. And in closing, I'll just say that I haven't been a federal prosecutor for about 15 years now, but in the interim, I was Deputy General Counsel at Qualcomm. So I understand threats to the nation's IP, but I also note that there needs to be a big acknowledgement at the FBI and the DOJ that there's a big difference between corporate concerns about espionage and the academic research community. They are different worlds. And the problem, I think, is that the FBI and prosecutors have essentially learned, they've grown up working with corporations and corporate concerns about IP theft, and they have simply moved that overlay onto the academic setting, which is completely different and which values open research. They are different, but to not understand that difference and to bring criminal cases against academia, that's a problem that the FBI, that lays at the feet of the FBI and the DOJ, and they should have done a better job. So, thank you.
Thank you, Carol. Xiaoxing, I think at this point you may have a question for Carol. Oops, did Xiaoxing dropped off? Oh, he has a class, that's right, yeah. So yeah, he has to leave, my apologies. So at this point, let me move to Gisela. You also have been very active with Advancing Justice and the AAJC.
Thank you so much, Jeremy. And I know folks have gotten a lot of information, so I'll try to keep this brief. I just wanted to take a step back for those who aren't familiar with the America Competes Act of 2022. And I also want to plug in the chat room our interest form for our upcoming amicus brief for Professor Shi. We hope all of you can support that this week. So real quick, as Nisha mentioned, the America Competes Act is the House counterpart to the Senate-passed U.S. Innovation and Competitiveness Act. It was agreed on February 1st with around 250 amendments. So what's next? Generally, there will be an upcoming conference. There, the House and Senate will need to craft a bill that's capable of passing both chambers. And so the sections of the bill I want to lift up are some of the differences. One are the immigration provisions that would be beneficial to non-citizens in STEM and Hong Kong and Uyghur refugees. This, along with KPAC Chair Chu's amendment, they're not included in the Senate counterpart. And if this bill was to move forward, we would want it to be included. Specifically on the immigration front, the bill will establish a new class of non-immigrant visas. This will apply to entrepreneurs with an ownership interest in a startup entity, essential employees of a startup entity, and spouses and children of W1 and W2 that I had mentioned. It would exempt from green card limits individuals with PhD in STEM fields, and non-citizens could gain permanent residence without being placed in the green card backlog or be subjected to per country limits. This is especially important for Asian immigrants, considering that our community suffer the most from backlogs. Lastly, a couple of the amendments from February 1st has created a few changes. One, the CAP exemptions are now extended to health professions in fields that are critical to US interests. And it also has created a special visa pathway for a limited number of scientists and engineers who are identified as contributing to national security innovation base. The other two things I want to flag is it does provide TPS and refugee status for qualifying Hong Kong residents. And it also provides essentially designates Chinese nationals and Xinjiang residents and those who fled Xinjiang after a certain time and are residing in other Chinese provinces or third countries, a pathway here to the United States. I will note that there's a firm resettlement requirement for folks who have or know any Uyghur refugees who are interested. And generally that has always been a problem in immigration court, as most refugees transit in countries and often find themselves stuck there. Lastly, the bill will also establish a directorate for science and engineering solutions with the National Science Foundation and also increase their budget. Part of this role is going to also include addressing competitiveness, cybersecurity, and national security as well. And so we're going to look to see if we can find more information about this new position. So I wanted to provide that quick breakdown in addition to what Nisha had mentioned. There are a bit of concerns that this bill is focused just on China. And so that is some messaging that we'll need to work with congressional staffers on. But otherwise, I'll provide Jeremy with a lot of this information that I shared. And thank you all for your time and for taking in all of this information from all the panelists.
Thank you, Gisela. I guess at this point, I'd like to raise one question for all the speakers. As you know, the China initiative is under review at this time. And an announcement of the findings of this review is expected in the coming weeks and perhaps days even. None of us believe that it will simply disappear. And so the question for all of you, and perhaps from the legal perspective, from the academic perspective, and also from the civil rights advocacy perspective, what do you envision China Initiative 2.0 will be like? And what should we do? Maybe I'll start with Rob and Carol from the legal perspective. What do you think will happen to the China Initiative, and your thoughts on that?
Carol, if you'd like to go first, that's fine.
Sure. Well, there's what I hope, and there's what I think might happen. I think DOJ I think they actually understand what the problem is. I think largely due to groups like this, they have been they have not only heard a lot of feedback, but I think that it's a different group of people, at least on the Department of Justice side, who have inherited this, as I call it, pile of poop. But there are political pressures that I think exist at by both parties that are concerned about efforts by China, which I think we all know do exist to some extent. It's just that this particular method of handling it has been somewhat misguided. So what I would like to see happen is I would like to see just this entire mantle of the China Initiative taken down, at least with respect to the Department of Justice and the FBI, because it is now so tainted, and I've made this point to the department. I mean, it is now so tainted, you can't unring the terrible bells that have been rung. Even if it could have rolled out originally in some fashion that was acceptable, it can no longer continue because it's just everything about it is bad. And so you could take down the formal structure of the China Initiative. If there are economic espionage cases to be brought, they should bring them. I mean, that is what the department does, and they should bring them with respect to any country that engages in espionage in the United States. So a lot of it is form, but for the reasons that we've articulated here, both because of the public perception of something inaptly called the China Initiative, and then in terms of the internal incentives and destructive tendencies that these initiatives have within the FBI and the DOJ, it should be dismantled in that process. I mean, if you look at Project Safe Neighborhoods, which was an initiative started by the Department of Justice, 20 odd years ago to try to deal with illegal firearms, and it created all sorts of weird and bad incentives where U.S. attorneys were stealing firearms cases from the local DAs so that they could, pump up the statistics. And now DOJ has come in and said, we are trying to reduce illegal firearms in all sorts of ways, not, and we're not aiming just for criminal prosecution statistics. But it took them 20 years to get to that acknowledgement that these initiatives lead to bad things. So my hope is, I think there's a chance that they will simply take away the name, take away all this, take away the incentives for people to pursue bad cases. I think there's a possibility of that, but I think there's quite a bit of pressure not to do it. Look, I think it is a good thing. At the end of the day, it was too late, but it is a good thing that they are dismissing cases that didn't have the evidence to support them. That's a good thing instead of just rolling the dice and going to trial. And that is perhaps the most important thing. But there are other things that DOJ needs to do. Rob?
Yeah, no, I agree with that. I think, and I worked when I was at DOJ, I was a member of many task forces, and you're right. If there's enough crimes occurring in every district, then there's something for those task forces to do, like drug crimes, gun crimes, human trafficking. You can find that in almost every U.S. district. But I think one of the issues with this initiative was that even if you read Attorney General Sessions, his press release when they started this back in 2018, of course, Andy Lelling was one of the 5 members who was U.S. attorney on that task force. You don't have espionage or spies for China in every U.S. district. You just don't, right? But then when you have the initiative, you have FBI agents and even OIG agents assigned to that initiative. If they can't find a spy, they're going to look for something that will get them a stat, as Carol knows. And I think what they were doing, and I'm still seeing it now, they then started scouring the grant applications from DOE, NIH, NSF, NASA. You had, as we all know, they have OIG agents who are federal agents at all those agencies. So it's pretty easy for them to issue an administrative subpoena to a university and then compare the applications they received at the agency. And therefore, you end up catching someone like Gang or somebody like G.K. Chang, who I have in Atlanta, or 5 other professors that I have now. What they're doing now, not only are they scouring grant applications, they're now scouring with the IRS tax returns to make sure that every dollar that's earned overseas was reported on tax forms. So this is a self-fulfilling prophecy, right? You have an initiative, you have a lot of agents who want in on it to get a stat, and they will then start going after very low-hanging fruit. And that was never the intention of the initiative. In fact, I looked at that press conference a few weeks ago from AG Sessions, and he never once mentioned grant fraud or tax fraud. It was all espionage, trade secret theft, which I think we can all agree, yeah, if there's trade secret theft going on in espionage, okay, do those cases, whether that is influenced by China or France or Russia or Israel, great, do that case. We should be doing those. But to focus just on academics and professors of Chinese descent who have nothing to do with trade secrets. No, I was just saying it's a major mistake, and I hope they move away from that and go after what they were originally trying to do.
Yeah, I'll just add that John Demers, who is the predecessor to Matt Olson, and so the previous head of this China initiative, he actually was on the record saying, we've told all the U.S. attorneys, and there are 93 of them out there, right? We've told all the U.S. attorneys, bring a case next year, or if you can't bring a case, like, we understand these cases are hard, but you'll bring one the next year. I mean, there's a quota requirement out there, if not formal, then informal, and maybe one case or 2 cases doesn't sound a lot to the public, but when you're talking about the Virgin Islands or Guam, where is your economic espionage case going to be there? And these are big, difficult cases. They're like Enron cases. I mean, you don't tell 93 U.S. attorneys go bring an Enron case, next year, but that's essentially what they've been told.
Zhigang and Gang, would you like to comment perhaps from the academics perspective? Yeah, go ahead.
Gang, please.
I just want to ask a question. Who is going to help those people, the prosecutor, the FBI, who incarcerate people like me, innocent people? They know better than anybody else, and yet they violate law. Who is going to hold them responsible? How?
Rob, you want to take that on?
Yeah, and I've had conversations with Gang about this. As Carol knows, there is an Office of Professional Responsibility within DOJ, and I'm hopeful they'll review this case and see where the breakdowns were. And there's also, Congress has oversight. As we know, the district court judges have oversight too. And there's many judges here in Boston that if this had been their case, we would have probably still been in hearings about why the case was brought to begin with, right? Judge Wolf is very well known, and he calls it judicial oversight. But many judges don't, right? Many judges will just dismiss a case, right? So I think that's what happened here. So now we have to rely upon OPR or maybe Congress to determine if there were any, if there was any negligence or major mistakes were made.
Yeah, I mean, there is a Hyde Amendment. There is a mechanism for bringing knowing and intentional, bringing a civil case against prosecutors who knowingly, intentionally pursue wrongful activity. It's a pretty high bar. There aren't very many successful cases brought there, and unfortunately. Unfortunately, the mechanisms that Rob mentions are there, and that's right. But I understand that that's not very satisfying, Professor Chen, for you personally.
Zhigang, your thoughts?
Yeah, so I'm just returning to this countervailing power compared to Carol and Rob were little potatoes. We the people, so many people, but each individual is very small. In my case, I'm an accidental activist. I happen to be the best friend of Gang Chen. I happen to know how good, just goodness. I have no other word to describe my friend. He just is a good person. I know him for 2 decades. When I heard he was arrested, I literally cried. How could this happen? How could this happen? I didn't feel I had a tool. I did not. I happen to have a Twitter account in which I told myself I would never tweet anything like a politics or anything I don't understand. I understand myself, so my subject is myself. I sing myself. My migration from China to this country, raised my children, and academics I know, the friends I know, I tweet about them, and all positive. There's not a single negative thing. Because in my life, very little negative things. And I tweet my research, but then my friend, I saw his tweet. I started to tweet, accidental activist. And I met very soon met Jeremy Wu and Stephen Pei. They were my teachers. They said, when you see something wrong, you should speak up. If many of us speak up, then people might listen. So I think this is a mechanism, organization like this, meeting like this should continue. Whether there's a China initiative, Japanese initiative, doesn't matter, because our government does not have the full power. Even though there are good lawyers, good prosecutors, but if you allow them to have all the power, absolute power corrupts absolutely. Also, there's a continuing sentence, great men are in general bad men. So that's a lesson I learned. So Jeremy and Stephen, I'll be your foot soldier for the rest of my life. Thank you.
Thank you, Zhigang.
Yeah, but one thing I really want to add is that this time, the faculties from MIT, Harvard, across the country set an example. We've been talking about the responsibility of the justice. We talk about the people on the prosecution and also investigation side. The other dimension is the institution. The universities, with the only exception MIT, university just threw the faculty under the bus. There's another issue we really have to review, that what the university should do in situations like this. I think we thank MIT and thank all the faculty this time to speak up. I think that really shine a light on the situation, another dimensional problem we haven't really seriously addressed yet.
Thank you, Stephen. I also want to mention that University of Pennsylvania faculty members just wrote to the faculty senate as well as the president, raising exactly these points. And that is, what are the roles, what are the responsibilities of university administrators? And this applies not just to UPenn, but essentially all universities across the country. And then that need to be addressed. At this point, let me also try to close this meeting with some good news. Some of you have heard about it already. And that is Professor An Minghu was the first academic to go to trial under the China Initiative. And soon after he was indicted, he was first suspended and then fired. And the good news is that effective February 1st, he has been reinstated to the University of Tennessee, Knoxville. So he got his job back. He was totally cleared. He was acquitted, even though the government tried twice, not once, but twice, trying to try him. So that's one bit of good news I bring to you, and if you have not heard about it already. And with that, I guess our next meeting will be on March 7th, 2022. And anyone with any last words at this point?